we got all of our bases covered for next week. The bills that might be coming over, and so far they're manageable, and we want to keep it that way. So on our schedule for today, we were going to do final action on 2102 and 2103, and the status of 2103 is we are going to hold that back depending on what the House does with Senate Bill 38. We are in communication with them, and we're trying to save printing a bill. This might just work. So that's the idea. We have no problem with the language. And on our egg bill, 2102, we had that listed for final action, but having heard the new information that just came, and then the work that's still being done and getting together with the proponents to find out what the right diagram is going to be, we are not going to work that today. So we'll pass over that, and we'll go into our hearings that we're scheduled for, and we have two good ones today, House Bill 2155, and so we'll open the hearing on House Bill 2155. Tamara, you were there from the reviser's report?
Good morning, Mr. Chairman. Good morning, committee. House Bill 2155 would strike current language regarding soil and water pollutant releases and cleanup, and replace that stricken language with new language regarding pollutants and cleanup. Specifically, subsection A of the bill would define relevant terms. And I will note that these definitions include the changes made to last year's version of this bill, which was Senate Bill 153, particularly for the terms pollutant and release. Subsection B of the bill would impose certain duties on the Secretary of Health and Environment, including adopting rules and regulations concerning responses to and reporting of pollutant releases, providing minimum reportable quantities, ordering cleanup, and taking necessary action to perform cleanup. Subsection C would allow the Secretary to provide guidance, oversight, and assistance for cleanup and response of a pollutant release, take necessary action to perform a cleanup if the responsible person fails to do so, and perform cleanup in an emergency. Subsection D, states that when a pollutant is released, the person responsible for the release is responsible for the cleanup and the repayment of costs incurred by the department for cleanup. Action could be brought against the responsible person if they fail to pay those costs of the cleanup. Subsection E would allow the Secretary to impose a penalty of up to $5,000 per violation. And in the case of a continuing violation, there would be a penalty fine cap of $15,000. And any penalty money received would be credited to the Emergency Response Activities Account and the Natural Resources Damages Trust Fund. House Bill 2155 would take effect upon publication in the statute book, and I'll be happy to answer any questions.
All right, thank you, Tamara, very much. Committee, any questions for the reviser? Seeing none, thank you, Tamara. We will move into our proponents. The first one on our list is remote, Bob Juergens, Kansas Department of Health and Environment. Bob, are you there?
I am. Yes, I'm available.
Welcome to the committee then.
Well, thank you, Chair Kirshen, members of the committee. I appreciate the opportunity to provide testimony in support of House Bill 2155. So as you know, KDHE is responsible for ensuring that notification, containment, and immediate cleanup measures are implemented for pollutant spills. We have a 24/7 spill reporting hotline that KDHE maintains 365 days a year. And so that is how the spill reports come in. As was already mentioned, House Bill 25 is identical to Senate Bill 153 from last legislative session. And that bill had actually passed the Senate 35-4, but died in the House just due to the early dismissal due to COVID. So the bill is identical to what we had last year. Tamara did a great job of explaining what was in the bill. So I'm going to move on to just a few of the key things. KDHE normally handles about 900 spill reports every year. COVID brought that down a little bit, as you can imagine, due to transportation reductions and facilities not in full operation. We had about 600. But we handle quite a few spills and work with our district offices to ensure the cleanup of those spills. However, many of those spills are really pretty low volume and relatively low risk to human health and the environment. And so the stakeholders that approached us a few years ago and said they would love to have some reportable quantities. And those reportable quantities would be thresholds to which they need to report a spill. This doesn't change the fact that any spill is supposed to be cleaned up yet, but the reporting of the spill to KDHE was a key part. And they wanted to be consistent with other agencies such as Department of Ag, with federal. The EPA has what they call a list of lists for hazardous chemicals that need to be reported. And then other states around us also have reportable quantities. And the idea is that by having reportable quantities, we can start to get some consistency from the federal level within the state as well as other states. And this is important when some of the companies have facilities just in various states. So maybe in Oklahoma, Missouri, Nebraska, whatever it may be. And so we were able to come up with the plan to be able to have these reportable quantities. Another thing we're doing is we've been working with Department of Ag to set up a reporting mechanism, because both of our agencies have reporting of spills required. There's for the ag chemical facilities, and we're going to work with them. And this is really not part of the bill, but it's two agencies working together to where we can have one call reporting to the KDHE spill hotline. It's all hazards number that can be called, and then KDHE will get that, and then we will forward the information over to Department of Ag. So we're excited about that. We know that the industry has been real interested in that. So as I mentioned, the necessity of the cleanup really doesn't change. That still has to happen. But if somebody spills a gallon of paint in their yard, right now that's technically reportable. Well, with reportable quantities, all they would have to do is go clean it up and they're done. So that'll make things a little bit easier in that case. This is also, hopefully will eliminate some of the confusion that folks have if they're looking across state lines. The penalties are actually very consistent with a lot of the other statutes that we have in different environmental programs at KDHE. And so that is why we chose the $5,000 max per incident, and then the 15,000 cap. The 15,000 cap was at the request of the stakeholders. And to give you an idea, we have never had a penalty in the spill program that was up to that 15,000. We have very few spill penalties actually. But this allows us that if somebody's a bad player, either they severely underreport something or they're habitual spillers that don't report and clean up their mess, so to speak, that gives us the opportunity to have that necessary regulatory enforcement should we need it. One of the big questions we got is, why does pollutant exclude animal waste that is used on normal ag operations on the ag facility? And that is just so, that's a beneficial use for them to use some of the animal waste to apply it on the fields. Well, we want that to still be able to happen. If there is transportation and somebody's hauling animal waste or crop waste out to the fields and there's an accident on the road, that's still covered by what we have. It's the normal ag operations that we're trying to stay out of their business, so to speak. And then the release, if there's ag chemicals, pesticides that are being applied per the product label, that's not a spill. We want them to be able to continue that. We are looking at more the bulk spills. A tote falls off a truck and, and we have kind of a bulk release. Those are the things we're looking at. The other question that's been asked frequently is, what if there is groundwater contamination or some sort of impact from the ag operations? Well, that's not covered under the spill, but it is covered under other statutes, regulations, either state or federal, such as Clean Water Act, or maybe the livestock program has requirements. The other key part is the spill law requires any spill that is going to threaten to get or has gotten to water, such as surface water or groundwater, to be reported. So we're covered in the cases of most things getting to water. I appreciate the opportunity to share this support, and I'll stand for any questions.
Thank you, Mr. Juergens, for that. Committee, any questions for Mr. Juergens? Senator Peck.
Thank you, Mr. Chairman. Looking at the legislation, I do have two questions. The establishment of a 24-hour telephone number, that does not necessarily mean someone's going to answer the phone 24 hours. It's just where they can leave a message.
No, that's actually been in operation for a long time, and we have staff that are on call. So if somebody calls that number, we do answer the phone.
Then On page 2, it talks about taking action to perform a cleanup of a release. This is lines 29, 30, 31, where the release cannot be identified or the person responsible for release cannot be identified within a reasonable period of time. What is a reasonable period of time?
There's not like a set, it's 2 hours or something like that. It really depends on the incident. So typically, if there's a spill out onto land someplace and there's not an immediate impact, it's not uncommon for us to give them, a day or so to get with the insurance company, get with their contractors to get things cleaned up. If that spill was next to a creek and we can't get hold of somebody, we've had incidents where maybe there's a fatality and it's hard to get hold of the company, then KDHE has the right to go in and quickly stop that. And we usually work with the county emergency management to stop the contamination from getting to a creek to make something worse. Or if there's storms are coming and we need to be able to get some controls in place, we do that. So it's not really a set or a defined time. It's just based on the situation. Very rarely do we have to do this. It's usually when we have to do is illegal dumping. It's out someplace we don't know who did it. But we've had a few where we've gone in, usually the day later or so, where we've taken action because it had to get stopped because there's big storms coming, things like that.
That was somewhat my point, Mr. Chairman, is reasonable period of time is a flexible definition. To me, a reasonable period of time will be certainly a lot different than my wife, a reasonable period of time when she tells me to do something. And I would think that might fall somewhat under the same guidelines here. And a lot of times, some of these releases, these spills, as was mentioned, we don't have any idea who it was or even when it was. We just found out, okay, we got a problem here, it needs to be cleaned up. I don't know if that's necessarily something we should, and I'll leave it to the time when we work the bill to determine if we need to establish or put a time frame rather than just leave it open-ended. Thank you, Mr. Chairman.
Any other questions for Mr. Juergens? Senator Francisco.
Thank you, Mr. Chair. So following up on that, I see that you can take action both if the person responsible fails to take it in a reasonable amount of time, and also if the release poses an emergency. So is there something in between those two that, I think the examples you gave were good about something in a field that's not near a creek. But what I heard you say when you talked about the reasonable period of time is that storms might be approaching, that would bring that pollutant into streams. So any other comments about the relationship between those two actions?
They just vary so much depending on the situation. And one thing I'd say, KDHE has no desire to have to mobilize our crews and pay our contractors to go out and do this work. So we usually go above and beyond, giving folks the opportunity to clean up their release. Sometimes you even have the county will jump in and do some temporary measures in place. So it would be hard to put that number out there, whether it's 24 hours or 48 or whatever it may be. But I can say we have no desire to have to be in charge of doing that. So we almost always work with the responsible party to get it done.
Okay, thank you. Any other questions for Mr. Juergens? Senator Fagg.
Thank you, Mr. Chairman. I was wondering, out of the 900 phone calls that you got, do you go out and follow up with these to make sure they get done on all of them or half of them? Just trying to get a feel of what you do after to make sure things get cleaned up.
Absolutely. We do have follow-up for each one because we do need to close out every spill report that comes in. So often that is done through a phone call. It could be the responsible party can go out, take pictures, send us a letter of what they did. They maybe will just give us an idea. Sometimes the county emergency manager may be involved and they'll kind of vouch for it. Other times we definitely have our field staff will go out, visit the site, make sure it's done. Often being there during the cleanup, especially when there's potential higher risk due to groundwater or surface water. So There is definitely a level of follow-up on every spill. It's just not all of them are in person at the site.
Thank you. Any other questions for Mr. Juergens? Not seeing any. We will call on, next up is Michael Gillespie from One Oak. Welcome to committee, Michael.
Good morning, Mr. Chairman, members of the committee. My name is Michael Gillespie, Director of Government Relations for One Oak. I appreciate you giving us the opportunity today to talk to you about House Bill 2155. This bill was before you last year, and we appreciate you considering this again with COVID and everything else. We just couldn't get across the finish line. But we do believe it's a good bill. I do appreciate Mr. Juergens talking about the bill, giving the overview, and what I would like to emphasize is this was a stakeholder and agency working group that put it all together to find a compromise to put industry and the agency on good footing so we all know what is acceptable, what we need to do. The biggest portion of what One Oak is, and I guess I'll give you a brief explanation of who One Oak is. One Oak is one of the largest natural gas and natural gas liquids pipeline companies in the country. We operate in 18 states, and we do have substantial assets in Kansas, about 7,000 miles of pipe, natural gas liquids, natural gas processing, storage, and transportation facilities. And so we do have opportunities, do have risk of spilling something. The main reason we are supportive of this bill is for the reportable quantities aspect. So if at our facility, if we were to spill a gallon of paint, we would immediately call KDH&E, say we spilled a gallon of paint, and then go through the full process. But if that paint had no impact to the soil, water, or the rest of the environment, more or less KDH&E files that away, and that file's never to be seen again after they follow up, and the same thing with us. This does not minimize our need to clean up things that need to be cleaned up. And so everything that touched the ground currently in Kansas has to be called in, every single drip or drop. And so this puts us at an EPA standard, hopefully, for different materials, so whether it's hydrocarbons, and I think fertilizers mentioned in there as well. So this gets to an EPA standard. So for One Oak, who operates in 18 states, we have something more comparable for our folks, so we know that everything, what needs to be cleaned up, what doesn't. If it's questionable, we still call it in. If it would be above or below this threshold, just to make sure we're doing the right thing. We want to be good corporate citizens, good environmental citizens, make sure that we're doing the right thing out in our areas because our employees work in those communities, our employees live in those communities, and we never do anything to negatively impact that. And so we're supportive of this. We appreciate KDH&E having a stakeholder group, having industry input, and moving us to a reportable quantity to help put us in line with a lot of our surrounding states and make sure that it's much easier to follow all the guidelines and rules. I'd be happy to stand for any questions at any time, but we're definitely supportive of 2155, and hopefully we can get this implemented as I think we started it maybe in 2019. So wanting to finally see something to fruition.
Okay, thank you very much. Any questions for Michael? Seeing none, thank you, Michael, for being here. Appreciate that. Next up for a proponent, Kansas Grain and Feed Association, Renew Kansas, and Kansas Agribusiness Retailers. Randy Stuckey, is that Abigail here to do that? Okay, all right then. So you're not making any comments then. Next we have, is anybody else that wants to be a proponent, wants to testify here today? Come forward, Aaron Papelka from Kansas Livestock Association. I have you down for written too, so.
Okay, I thought I signed up as oral, but
that's all right.
Might have been my mistake. So I'll be brief. I just wanted to highlight the points Mr. Juergens made about agriculture. Back in 2019, for those of you who are on the committee, probably remember we were originally opposed. We went to that stakeholder meeting that Michael mentioned. Our main concern was we're doing a bunch of definitions, new definitions, and the original ones back in 19 that aren't actually in this bill, we thought were a little broad, could bring in some normal agricultural activities that weren't meant to be regulated by this. And so we worked with stakeholders, got those particular instances excluded. And so we're now a proponent of this bill and would like to see the committee move forward. So I stand for any questions, Mr. Chairman. Thank you.
Okay, thank you very much. Any questions for Aaron? Seeing none, thank you very much. Committee, I draw your attention. Anybody else that wants to speak as a proponent? Seeing none, we will move to, in your agenda, which says written proponent testimony from, we call on, it's Kelly Kelsey from Evergy. That's written only. And next, we'll move to neutral testimony. And we will start with Ed Cross from Kansas Independent Oil and Gas. Welcome to the committee, Ed.
Thank you, Mr. Chairman, members of the committee. I'm Ed Cross. I'm the president of the Kansas Independent Oil and Gas Association. And I'm just brief today. It's neutral. I'm just wanting to make sure all the committee members are informed and also be on the record to know that there is a memorandum of understanding between the KDHE and the Kansas Corporation Commission that gives the Kansas Corporation Commission jurisdiction and responsibility for any spills from oil and gas exploration and production activities that do not get off lease. If they get off lease, then they obviously goes to EPA and KDHE. But I just wanted to make sure it was on the record to know that there is a memorandum of understanding between those two agencies that gives the KCC jurisdiction for oil and gas exploration and production spills. And I would stand for questions.
Okay, thank you, Ed. Any questions for Mr. Cross? Seeing none, thank you for your input. Next, we have under neutral, Zach Pistor from Kansas Sierra Club. Welcome to committee.
Hey, thank you, Chairman. Great to be with you all. I haven't got the chance to make it up here as often as I normally do, so I just want to say it's a pleasure to see you all, and thank you for your service to the state, especially at this time, looking back after a long year of the pandemic. I'm Zach Pastora, proud lobbyist for the Kansas Sierra Club, organization dedicated to protecting the great outdoors, represent about 5,000 people across the state of Kansas. And we're testifying neutral on this bill. We support all efforts to expand the ability to protect our natural resources and environment in Kansas. And certainly the testimony from KDHE is positive and gives us comfort in knowing that this bill will pass favorably for the environment as well. You know, what came down to for us in thinking about this bill was just the ability to address non-point source pollution. The specific language that gives us a little pause and gave a number of your colleagues on the House side some pause is this line that excludes animal or crop waste or manure from being classified as a pollutant. That's page 2, lines 11 and 12 of the bill. And the reason we point that out is because it could consequentially complicate the ability to address non-point source pollution and lessen the liability and responsibility for our agribusinesses to prevent water and soil contamination from animal and crop waste and manure. And don't get me wrong, I think farmers and ranchers, including myself being from a farm family, are good stewards of the land and care about the environment. I think we all care about the environment, and including industry behind me as well. But as far as the non-point source pollution, I mean, I don't need to tell you all that we've had problems with harmful algal blooms. We've had problems with nitrites and nitrates in the water, creating water undrinkable for some of our Kansas communities. And what we call normal agricultural activities comprise one of the leading water quality impairments for rivers and streams. So absolving agriculture in this way, by excluding them in the definition of pollutant, could misalign environmental protection efforts between state and federal entities. I'm glad to hear that the Clean Water Act, Safe Drinking Water Act, and some of our permits will still apply to all this, so that's good. But just want to provide a little pause on that specific line of animal or crop waste or manure not being classified as a pollutant. I think we can change the language to say it can be a pollutant, not necessarily shall be considered a pollutant, but may be considered a pollutant, for example. And that's just because we don't want to relax, give the false impression to Kansas that, you know, manure or livestock waste couldn't have a potentially negative effect on our ecosystems. That's all we're trying to say here. Just for example, I put in my testimony, I hope you'll get a chance to read it, that the National Water Quality Assessment shows that agricultural runoff is the leading cause of water quality impacts of rivers and streams, third leading cause for lakes, and second largest source of impairments of wetlands. So, it's one of those things where in and itself, I put manure on my garden, on our farm. It's in itself not a problem. It's just if it gets into, leaches into the soil, gets into water ecosystem, causes damage, is the problem. And so that's why we're neutral on the bill. So I encourage the committee to take a look at that language and consider this issue going forward and stand for any questions. Thank you.
All right, then. Thank you very much. Any questions from the committee? Senator Straub.
Thank you, Mr. Chairman. And this might be a question actually for one of the revisers. In current law, are spills and runoff classified differently, or are they encompassed, are they both under a spill?
Jurgens, you still there? Hello, Mr. Jurgens. We had a question, if you could take it here.
Yeah, so right now, any type of substance that alters the natural, physical, chemical, biological state could be considered a pollutant, but we consider spills to be concentrated releases of some sort of chemical or some sort of a product. KDHE does not handle non-point solution or pollution through the spill program. They're handled through other programs if there is that ability. So whether we specifically could say a non-point source is handled by another program, it's a variety of them. And that's why we have outreach programs that try to prevent some of those. But there's not necessarily the regulatory authority under the spill program for non-point source.
Thank you, Mr. Chairman. So House Bill 2155 that we're currently talking about deals with specifically spills. It seems that Mr. Pastora's testimony is more in relation to runoff. Do you disagree, Mr. Pastora?
No, I don't think so. I think in the sense of protecting the environment, yeah, I just wanted to bring up the concern for your consideration. Any way that we can make sure that, the pollutant language in law, that there's no conflicting points of statute, if that makes sense. If we classify animal agricultural waste as not a pollutant in one part of the statute, and then maybe in our other authority dealing with runoff is, I just think if we can pretty much say that it can be a pollutant, why are we putting that language in statute? That's all.
Okay, thank you. I just wanted to clarify so that the committee is not confused that this applies to runoff when we're talking specifically about spills.
Sure. Yeah, if
Okay.
it's a difference of
Thank
point
you.
solution versus non-point solution, I'll take your point.
Thank you.
Yep.
Thank you very much. Any other questions for Zach? Thank you, Mr. Jurgens, for answering, helping us on that too. So, seeing none, thank you very much. Anybody? We have a written neutral testimony from Ken Titus from Kansas Department of Agriculture. That's the only one I see. Is any other neutral testimony for today? Seeing none, we will ask for opponents. We don't have any listed. Are there any opponents that would like to speak today? Seeing none, there are no opponents. We will close the hearing on House Bill 2155 and open the hearing on House Bill 2172. And we will begin with the reviser giving the report of House Bill 2172. Tamara?
Thank you, Mr. Chairman. House Bill 2172 amends KSA 82A 736, which relates to multi-year flex accounts, or MIFAs. Multi-year flex accounts allow a water right holder to obtain a 5-year permit that would replace their base water right during the 5-year term of that permit, which allows their authorized quantity limit to be based on a 5-year period instead of a 1-year period. Under current law, the 5-year allocation of water in a MIFA is determined based on either the base average use or annual net irrigation requirement. And the base average use is the average amount of water diverted under the base water right during the years 2000 through 2009. However, in reality, there have been water rights that have been perfected that really don't neatly fit within that time frame. So House Bill 2172 would address that issue and would allow a new alternative base average use calculation for those particular water rights in order to determine their MIFA allocation. The bill would also allow a MIFA term of less than 5 years if the chief engineer determines it is necessary for compliance with a local enhanced management area or intensive groundwater use control area. Additionally, the bill would address the existing prohibition on participation in a MIFA if the water right has ever been subject to a change approval that expanded the acreage due to implementation of certain regulations. The bill would limit that prohibition to only those water rights that are currently the subject of a multi-year allocation due to a change approval instead of at any time. The bill also includes technical cleanup of a few outdated provisions. And finally, the bill would take effect upon publication in the statute book, and I'll be happy to answer any questions.
Okay, thank you, Tamara, very much. Any questions for the reviser? Not seeing any. Thank you very much, Tamara. Appreciate that. We will begin with proponent testimony, and we will start with Ken Titus, Kansas Department of Agriculture. Welcome to the committee again.
Thank you, Mr. Chairman, members of the committee. My name is Kenny Titus. I serve as Chief Counsel for the Kansas Department of Agriculture. We're here today in support of House Bill 2172 regarding our multi-year use flex accounts. MIFAs have been an effective tool for producers. They help when years turn dry and when we need drought mitigation. They also serve as useful 5-year planning tools, and they're widely used by a number of water right users across the state. Tamara gave an excellent summary of how the bill works, the changes we're proposing, so I won't go into that in great detail, but just to say there's a significant number of water rights that have been perfected since 2009. Most of them start along that I-135 corridor and move to the east because the areas west of there are generally closed to new appropriations and were closed by the time this went in place. But for the eastern third or maybe even 2/3 of the state, there's a number of water users that would benefit from this change. We've studied this program. We found that it does not cause any increase in water use and in many cases facilitates less use. So this has been a good tool. It's been helpful to folks. People that have a suite of water rights, some newer, some older, it can be confusing for them which water rights are eligible when they're trying to manage a number of properties and remain in compliance. So it's been a good tool for them as well. I'd remind the committee this passed the House last year and got out of Senate Ag before it died with everything else. So I'm happy to stand for any particular questions you might have when appropriate.
Okay, any questions? Senator Dahl.
Thank you, Mr. Chairman. Kenny, what's the penalty? I know this doesn't apply to a lot of us in western Kansas, but I know farmers that will just even prepay the fine because of, their corn's worth more than that.
We've, so it was 2 or 3 years ago, we significantly, because of feedback like that through the water visioning process, we significantly increased our penalties where that's a much less economical choice for farmers to make now. And this tool, so that we have some certain standards, if you haven't had a previous penalty in the last 5 years and it's not an egregious type penalty, and you come to us before the end of the year, so the deadline on getting into one of these is in December of the year you're in. So if you check your meter during the year and are on top of it, you realize, oh, I'm going to overpump. If your water right's in good standing, this is one of the tools. If you're timely, you can come in and you can get it, and then that sets you on a 5-year window and can help people manage a difficult situation, especially if it turns dry, late summer. It might be a situation where this would be common.
Any other questions for Senator McGinn?
Your map just confuses me. This is a tool to not use more water.
That's correct.
Right? And you have to use what your allocation is in that 5-year period.
That's right.
Yeah. So I'm just looking at the first map, kind of looking at my area here. I've always been told it's over appropriated. And I believe this says water appropriation rights approved since 2009. And I'm looking at Harvey County and Sedgwick County. Those are all new. I assume mostly Center Pivot approves.
I do not have the breakdown on what those are, but those are new applications. Now, if you look at the third map, you'll see not all of those ended up being certified. You know, that would be a case-by-case look, but that is the correct representation of a total applications.
The third map, though, is the certified under MIFA.
Those are ones, right. Those have come to completion and could get into a MIFA that we know for sure would be eligible. And you can see the different type of uses in by irrigation and stock, and you can see that it's a smaller number, but they do lean towards irrigation in Harvey County.
I'm just surprised since that has been the amount of water rights released from 2009 in an area that I thought was appropriated.
I know that when we work applications in that area, we use a safe field measurement. We work with the local groundwater management district, and I know they do find throughout that area in general, they do find areas where there is room with the safe field calculation for new water rights, and it's not. There are some areas that are closed, but it's not a generally closed area.
You guys have this. Can you break this map down and send it to me of what is like a small user permit versus a center pivot?
Yes.
Okay, thank you. That's all I had. Thank you.
Any other questions, committee, for Mr. Titus? Senator Francisco.
Thank you, Mr. Chair. And this is, when you talk about water use records are inadequate for that 10-year period, and you're looking for 5 years, in what way are they inadequate, or?
So it can vary. You can have years where ownership has changed and the previous person just they may have been penalized, for example, for bad, I don't want to say false, but just their meter broke, they estimated, and that can happen to somebody who they may not realize until a certain point. We can put electrical records and get a guesstimate, but sometimes that doesn't always happen the way it ought to. Sometimes it didn't happen very well in the past. So someone could come in with a new water right, and we'd like to have some flexibility to help those folks for something that may not have been their fault in the past. We thought 5 was a good minimum. The other thing that came up along with records not being good, you could have a year where if you had a hailstorm come through early in the season, you end up using 0 or almost no water. So you've not used the water for good cause because your crop failed, which is not good. But you don't want to penalize them for the total amount of water they'd have available in a 5-year period because of something that was out of their control. So we talked to all of our 4 field offices and went through this and decided that we needed some clarification on how we deal with this because the circumstances are pretty varied.
Any other questions, committee, for Mr. Titus? Seeing none, thank you very much for being here today. And at this time, I'll ask, is there anybody else who wants to testify as proponent on this bill here? Seeing none, we will move to neutral. Or anybody want to testify as neutral on this bill? Seeing none of those, we'll go to opponents. We have written proponent testimony from Sean Miller from the Kansas Groundwater Management District, Kent Ashman, Kansas Farm Bureau, and Josh Rowe, Kansas Corn Growers. Those are written proponents. Now, is there anybody who would testify as an opponent? Seeing none, we'll close the hearing on House Bill 2172. And that's the last item on the agenda here, committee, unless somebody else has something to bring up. There's none. We are adjourned. Thank you.